Welcome back to this conference on the separation of powers in 21st century Europe on the role of the judiciary. My name is Anna Gavanini and I will be chairing this session. And I'm very pleased to welcome our keynote speaker, Professor Urska Sadl of the European University Institute, who is visiting us and will give the keynote address on the European Court of Justice as a discrete lawmaker. We're very much looking forward to it. Urska, please.
Thank you, Anna, and I only hope I'm not muted because I don't know how to do that for my presentation. So I'm super happy to be here today, and I'll try not to speak so long. And I'm really sorry I changed the title of my presentation. I hope nobody noticed. So I tried to adapt my presentation to the theme of the Sapporo project, and particularly for this conference. And I might not be spot on with the topic, but I might offer a complementary view and sort of an outline, an approach to the study of separation of powers in the 21st century Europe. And I mostly speak to the part of the project dealing with rights-sensitive power shifts away from courts and potentially towards the executive, but almost always from the EU to the national sphere. And I also speak to the part of the project that aims to conduct empirically grounded research to better understand such shifts in the particular context of the EU. That I read from your website. And I hope that my contribution can be of some assistance in rethinking the theory and practice of separation of powers, and that in the fields that I unfortunately know very, very little to nothing about, and words that I have been trying very hard to avoid. That's the economic and monetary union and trade. And here's where I am here to learn from you today, and that's one of the reasons why I'm very happy to be here. And so I have more patience for and greater interest in migration, and I also dare to argue that the free movement of persons that I deal with is controversial and illustrative of power shifts. And the bigger question, I gather, is the role of courts in the process that the project refers to as the will formation and control of those in power. So let me jump in at the deep end of the pool. So what puzzled me was how courts could let both parties win the case, and in a zero-sum game, how could there be two winners and no losers? And the starting point of the inquiry was a metaphor that the Court of Justice developed with far-reaching doctrines in a cog and wheel fashion. And it was statements scattered across the stuff that I was reading, like Hartley's EU law or Karen Elter's political power of the court, and Helfer and Slaughter's stuff on effective supranational adjudication. And there's always been the sound of Takis Trudimus from Bruges, who was telling me that the court was always trying to apply fairness to the facts. And these figures of speech conveyed this impression that we were dealing with judicial prudence, with wisdom and situation sense, so that we were facing what you could call an integrationist alchemy. And so these figures of speech were illustrative precisely because they left important detail hanging in the air. And I'm a lawyer, so I was most of all interested in that detail about what we call a context-conscious judging. So I had two questions. What is context-conscious judging, legally speaking? So what happens to the interpretation of rights, precedent, structure of legal justification when judges tailor the meaning of rules to their political, legal context, or where they apply fairness to the facts? And how can we design a legally informative empirical analysis of this process? And the question is, of course, why do we want to know, apart from the fact that our life depends on it, that our lives depend on these people, our rights, and that the trust in our institutions and political processes depends on our trust in the process of adjudication. So in more technical terms, why are these questions, the way I formulate them, why are they interesting? So what I'll try to argue today is that social sciences focus on the mechanisms of context-conscious judging, on why things happen, and that legal empirical research focuses of the, not empirical legal, but legal empirical, and I stress this, focuses on the mechanics of context-conscious judging, so on the question of how. But importantly, and here is the claim that we cannot understand the mechanisms without understanding the mechanics. And to try to gain this understanding, I sort of developed a research strategy that I tried to follow. So I tried to ask a legal question, a conceptual legal question. I tried to find a theoretical framework. I tried to break down the main concepts, and I tried to use the legal vocabulary to translate those concepts into theory. And then, of course, you come to the question of method, and because we have so little to work with, I tried to borrow a tried and tested approach. Now, this approach, I thought somehow naively, I would calibrate to speak to my research questions, and I would trust the method that was there. So here is where I can cut my presentation a little bit shorter. I don't want to bore you with what many of you know better than me, but there are some accounts of judicial decision-making that seem to speak to my object of inquiry. And most of them also included a research agenda or an approach or a methodology. So what is common to these accounts that might look different are that they all still believe in the relevance of rules. They disagree only about the stage to which context, at the stage at which context takes over. And the question is, right, so I'm trying not to be too theoretical because I'm going to be out of my depth, but these accounts, they're not deep rule skeptics. They're not deep rule skeptics in the sense that Scandinavian legal realists are deep rule skeptics, right? They are skeptical about how these rules are applied by courts, but they do not question the law and the rule. So for example, consequentialism, what we deal with here is McCormick says, okay, judges solve a case. There are several equally justifiable solutions to the case that are within the meaning of rules. The judges will select among those different alternatives the one that promotes the legal values to the greatest extent, that has the best societal consequences. Right? So this is what we call consequentialist accounts. So Shapiro at the other end of the spectrum says, "Oh, listen, guys. This is not even close to it. This is some sort of bounded rationality. Judges don't even look for all possible rational solutions. They're more like administrative decision makers. They just try to do what's simplest. Like let's just get this over with, right? So this is where we are on the spectrum. And here I start paraphrasing myself a little bit. What these accounts lacked was detail. What legal accounts lacked was scale. But none of them, to my mind, could really be applied to larger collections of judgments. So both of them, whatever you chose on this spectrum, had to be operationalized. And I thought the business I'm in now, after all of this, is to design a metrics to identify and to measure the scope and the quality of interaction between law and politics. So to measure the scope of context in the law, in the legal decision making. So these theories were good for was to formulate certain hypotheses. And these hypotheses I formulated with the European Court of Justice in mind. And these hypotheses are already a work of translation of the theory into analytical framework. So I try to use these theoretical accounts to reformulate deeper questions about judicial decision-making, but still make them sort of set up in the way, or I could read judgments and try to apply this framework to get to my research, to answer my research question. I was just wondering whether I should pause here and ask whether there are any questions. No. Okay. So there's 3 hypotheses. I'm going to come back to these hypotheses, so you don't have to remember that, but they go from milder to stricter when it comes to transferring power from the court, from the judges to the executive, to the national governments. So if you remember, I had 2 questions in the beginning, and now I had 2 problems. So I had the conceptual and the methodological problem. So that was only for the starters, and next conferences, when you meet, I can come and tell you about further problems. So the conceptual challenge was that the terminology of incrementalism and minimalism and half a case at a time lacked transposition. Again, I'm paraphrasing myself, in the vernacular of justification, argumentation, doctrine. Now, the methodological challenge was, how could we annotate hundreds of judgments in a way that preserved legally relevant information, but still on the level that allowed us to study trends and patterns? So how could we reveal the reflection of context in legal reasoning? So how do we reveal the scope of politics in law? And then it struck me, I was not only struggling with concepts and methodology, I was struggling with the lack of there being already made analytical framework. So I sort of set out to devise that analytical framework. And the main idea, or the main concept, the central concept of this analytical framework is a concept of a discrete judgment. And the main characteristic of a discrete judgment is an asymmetry. I could give you an example. It's going to take a long while. Maybe I can come to it later in the discussion. But it's a conflict between the court's decision about the claim and the reasoning that supports this decision, or a disconnect between the court's interpretation of the law and the method that the court uses to arrive at this interpretation. And this can be observed as the asymmetry between the reasoning, the interpretation, and the case outcome. And I say that this signals discreteness. And then I say, well, there are 3 types of asymmetry that come from my 3 hypotheses. And I'll also return to that. So with regard to method, so that is the work that had to be done. And I thought, how can I do this? So I thought of something that I call the deep legal coding. It is a structured reading of the case law. And it is simply a classification of characteristics or parameters of judgments that we identify in coding guidelines, which are pre-established, and coding protocols. And what is important here is that these selected characteristics that we identify approximate the fundamental components of judgments. So, and that's why coding these parameters can lead to revealing the asymmetries between the fundamental components of judgments, reasoning, interpretation, outcome. So the aim, you remember, is to deliver a comprehensive, doctrinally meaningful treatment of the legal materials. But the method is obviously not perfect. And the coding sometimes discounts important legal features or legal features of judgments which were important for the development of the law. So it omits doctrinally interesting aspects or arguments of the court. And these are the aspects which we find after reading a lot of cases too uncommon to actually generalize to many judgments. So for instance, if you have free movement of persons, there would be only 2.6% of those judgments at raising the question of a purely internal situation, right? The question of a purely internal situation in free movement case law is an interesting one, but actually when you look at the cases, you find that only a handful of cases actually raise this doctrinally interesting question. So like on the plus side, this process retains these aspects of reasoning that can enhance the understanding of the court judicial making process, right? So I'm not primarily interested in understanding the law, but to understanding the judicial process. And this is where there is this compromise. So from this perspective, right, even if we would say, okay, but this is a purely internal situation, and then further distinguishing cases which deal with the purely internal situation would not bear analytical fruit, or that's what we assume in analyzing the patterns of how the court actually makes law. Now, one advantage, and this is I add this to the presentation because I got a comment on this. So one advantage of deep coding is that this does not depend on constructing an absolute and very demanding benchmark on convincingly establishing of what the law means, what is the correct meaning of a legal provision. So this is the classical locus of disagreement among commentators, right? So asymmetry arises from a specific interaction of these parameters. So it is not based on the finding that the court's interpretation deviated from the established or fixed or settled case law, or deviated from the norm. So rather, the analysis would indicate an asymmetry when the findings show that the court interpreted the legal provision broadly, and that is sort of the value of one parameter, but that its application, which is captured by another parameters, have values which point that there is an asymmetry in the process of rational justification, right? So it's basically an anomaly or a departure from the structure of rational justification. So I started talking about these parameters, but without telling you how parameters connect to the idea of discrete outcomes. So the parameters, let's remember, capture the method of the court, the decision about the court's claim, and the interpretation of the law. And if these are not in sync, not symmetric, the outcome is likely discrete. So discrete outcomes are asymmetric. And how do we try to test this? Is this something that we just came up with? And we is not me, we the royal we, but we were many people working on this. And how do did we really come up with something that could be operationalized and used for case analysis and analysis of judicial lawmaking? So we said, okay, but let's look at the free movement of persons. And this is, I did because I just knew this case law best. And there's around 1,100 cases, and they include workers, social security for migrant workers, citizenship, and some equal treatment cases. And most cases would concern the free movement of rights of workers, their rights when they retire, their rights when they become sick, unemployed, unable to work, and also for the members of their families. And those members can be either EU citizens or third country nationals. And for me, this case law was, like a good test bed for examining the role of context in the legal decision making, because there was a clear opposition between the individual and the collective or member state interests, and this conflict was consistently present even in so-called clear or easy cases. So these are cases, free movement of persons cases, let's say, I dare claim, are cases where principle and politics often collide, and they often do so with not such great outcomes for individual rights. So this relationship, sort of try to bring this closer or kind of like tie it up a little bit with the analytical framework, is that the contradiction, the tension between the meaning of the law, the normative argument, and the decision about the claim, the outcome, and the methods of arriving at the meaning of the law can then be formalized as a relationship between these legally relevant parameters. Okay. So what parameters did we use and how did we design them and where did we find inspiration? And we found inspiration just by reading the case law and trying to see what these cases were about. Prima facie, there were 5 of us who were reading all the cases where free movement appeared. And then we were reading textbooks. I don't know, Catherine. I was in charge for Catherine Barnard. Others were reading EU law, published different publishers over the years, several editions, and so on. And then we thought, okay, let's design these parameters. And some of the parameters were general, some were particular to free movement, and some were case specific. And the general parameters would apply to things that we normally study in EU law across board, like autonomy of the member states, deference, proportionality, doctrinal outcomes, whether state measures are upheld or repealed. There were parameters which applied mostly to free movement of persons, to derived rights, family rights, financial solidarity, equal treatment. Some were clearly taken only from doctrine. One is financial solidarity. And then there were case-specific parameters. And these parameters we tried to use to gauge the effect or sort of the particular effect of facts and contexts on the law. So basically what kind of context do we take into account, right? Does the court judgment depend on the type of the applicant, right? Does the court's judgment depend on the type of the benefit that the applicant is claiming, applicant in the main proceedings, sorry. And this is how, let me illustrate, do you see this? So this is an illustration of what the research assistants actually do, how they do it technically. There's a coding platform. It's online. It's on Shiny Apps connected to the server for which you're paying $440 per year, which always pays me because I think this thing should be free, right? So you develop a platform, an online coding platform where a person logs in. So I think I'm logged in as Urska. You have the case on the upper left side. And then you have the variables and you record it, you record your value, whether in this case, Commission versus Greece, you think that the court is increasing or restricting the autonomy of the member state. If you think that, then you have like a bracket where you record the text, copy paste the text of the judgment into the platform so that the text can be separately analyzed and processed, right? So the research assistants both record the value of the parameter, pro-autonomy, anti-autonomy of the member state, but they also paste the text, right? So you can check whether the research assistants came to this conclusion for slightly different reasons, or what did the text that they consider representative of the value, what did they think about that? And I can tell you this is very interesting. So again, 3 types of asymmetries. A reminder: non-sanctioning Europeanization of national rules and policies, differential upholding of European rights against the state, and bounded undesirable interpretation. So if we look at all these cases, what do we find? So there's cases from the 60s where we have very few cases where I don't think any of this is very, very reliable, but I put it there mostly to illustrate also how many cases we were dealing with per each five year period. And when we're talking about the context consciousness in the sense of non-sanctioning urbanization of national rules or policies, so the cases that I have in mind, and this is always very difficult, right? Because lawyers disagree whether this really is the case in point or whether this is not an emblematic case with this asymmetry. So what I took was saying, okay, let's trust the method. Let's see how cases are coded. Let's try to see how I set the parameters. I listed all the cases that the research assistant coded as type 1 asymmetry. And for example, the first type is the Groner case, if you remember, a part-time lecturer that did not speak Irish in Dublin. So the type 2 asymmetry is a differential upholding of European rights against the state. And an example is a very old case, the Vassan and Goebbels case from the courts, I think it's 1963 or 64, which is a security case of a widow of a minor who moves from Netherlands to Germany and is disaffiliated from the sickness insurance scheme. And the third type of asymmetry, the bounded undesirable interpretation, one example of this is the Bressol judgment. And I sort of put these judgments as examples because I used old examples, right, to sort of analyze myself through this coding, because there I had the full course file available. The archive rule is 30 years, so except from Bressol, and I had some other documents available, like for example the reports for the hearing, right? And then these extra documents sort of helped me verify, or I thought they were helping me verify, that indeed that there was a very contentious sort of political climate, that the member states were arguing, that the court probably was dealing with a politically rather sensitive issue, right? A very cute example of this is Vassan and Goebbels, where there's the 60s, and you have the Dutch government claiming, but listen, if this woman who moves to Germany, she still is entitled to this benefit, to the voluntary sickness insurance scheme. She never worked in Holland, right? Her husband worked in Holland, and now she's moving to Germany and taking the benefit, right? This is really then the people are just going to move to those member states where they get the greatest benefits, right? This is the 60s. And the Advocate General says, what, are you crazy? I don't buy that for a second, right? So surely people would not move just because of the benefits, right? But there is this question, right, which later becomes persistent, and you can see that the court was dealing with these kind of arguments, right? So for example, with the Groner case, of course, what we were dealing with is the Irish initiative, where they wanted to reinstitute Irish as the main language, right? And this is why it was very important that all lecturers, full-time lecturers and employees, especially universities, actually spoke a little bit of Irish. And it went against Ms. Groner, because Ms. Groner happened to be, for I don't know what reason, but she happened to be the only person who did never pass this exam, right? So but there was a charged political situation, right, where Ms. Groner complained to the European Parliament, apparently, right? The Parliament took it up, and so on and so on, right? So we had a whole drama saga unfolding, right? And then this court case, which seems slightly off, right? But the court is really faced with the situation that it just does not want to get into the Irish Irish language, huh? Exactly. Doesn't want to get into this, but it has to somehow mitigate between these conflicting interests, and this conflict actually shows as an asymmetry in the structure of justification. So I'm not putting too much emphasis on these numbers here on the table, and this is because there is a caveat, right? Asymmetry signals discreteness, right? Asymmetry is a signal that the court might want to be negotiating the extent to which European rules apply, to whom they apply, and how to apply, right? but it does not signal that it is actually politics talking, right? So we have here the scope of asymmetry in the free movement of persons case law, but what you would need to do from now on is actually try to establish whether they were or were not motivated by the political context or the facts of the case, right? So we can design from here on a qualitative study or try to set up statistical models to actually start testing this. And this is what we're doing in another paper. So I would like to conclude by saying that courts respond to context. Sometimes they do so for political reasons and sometimes by adopting discrete judgment. And that I think we should be able to identify and to measure this. And I also claim that we can do this by observing asymmetries because discrete judgments, they deviate from justificatory routine and they strain the logic of legal justification. So the court might be negotiating the boundaries of the law or giving into the political branches. And this is why this is maybe interesting for you to study further. So conclusion, this is a footnote here, is that I'm fully aware of the fact that there can be symmetric discrete judgments, that there is a question of how to present the facts, that there is a question of how to select the precedents. But I'm not sure how to exactly study those symmetric discrete judgments, apart from statistically designing a model where we could see how different characteristics from my data, how different characteristics of actors translate into specific case outcomes. Okay, so thank you very much for listening to me. I hope I was not too long. Okay, thank you, and thank you again for the invitation. I'm going to.
Thank you. Thank you so much.